Welcome, everyone. Thanks so much for joining us today. Just going to give folks another minute to join. Looks like there's a lot of folks joining in right now. And so we'll get started in just a minute. Good afternoon, everyone, or good morning if you're joining from the West Coast. Thanks so much for joining us today for this seminar on Asylum 201 for Afghans, Bars to Asylum and Common Concerns. Just wanted to make a note at the top. This is being recorded, so we will have a link to the recording afterward if any colleagues or friends wanted to attend but missed it. We'll also be able to share the slides for folks who weren't able to make it or wanted to refer back to them because there's lots of material that we're covering today. It'll be very difficult to remember it all off the top of your head. So it'll be hopefully a useful reference for folks later on. For folks who are joining us interested in CLE credit is available for certain jurisdictions. It's being provided through the generous support of our law firm partner at Skadden. We will be circulating a CLE form immediately following the training with additional information about how to apply for the CLE credit. So in addition to that, we will be reading a particular code towards the end of the training that you will need to use to complete the form. It's a very special CLE code for this presentation. So please be on the lookout for that and make sure to note it so that you can complete the form and get the CLE credit if you're looking for that. My name is Rachel Zaglan Bautista. I am the Associate Director of Pro Bono and Partnerships at HIAS. We are so happy to be joined today by our fantastic panel, Faiza Syed, who is the Assistant Professor of Law, Director of the Safe Harbor Clinic at Brooklyn Law School, and Persecutor Bar, an immigration attorney at the Law Office of Zahedi, and a member of the American Immigration Lawyers Association Board of Governors. I just wanted to introduce you a little bit to our fantastic panelists today, and then jump right in because we do have quite a bit to cover. Faiza Syed is the director of the Safe Harbor Clinic and teaches courses in refugee law. Her scholarship focuses on how immigration law intersects with other areas, including criminal, national security law, and explores the ways in which law can protect the rights of vulnerable immigrant populations while still achieving other desired immigrant policy outcomes. Her article, Terrorism and the Inherent Right to Self-Defense in Immigration Law, was published in the California Law Review, and her latest article, Secret Immigration Law, is forthcoming in the Northwestern University Law Review. She began her academic career teaching as a clinical teaching fellow and supervising attorney at the Center for Applied Legal Studies at Georgetown University Law Center, where she supervised and taught law students representing asylum seekers. She also previously served as a refugee officer for U.S. Citizenship and Immigration Services, and as a law clerk for the Honorable Kimba M. Wood in the U.S. District Court for the Southern District of New York. Persecutor Zahedi is a private immigration attorney. Her practice ranges from removal, asylum, and citizenship issues to employment and family-based immigration matters. She is serving as an elected member of the American Immigration Lawyers Association Board of Governors, and she serves as co-chair of the American Immigration Lawyers Association Afghan Task Force Committee. She's also a member of the Annual Conference Committee, Member Engagement Committee, Online Course and Recorded Content Review Committee. She served on the American Immigration Lawyers DC Chapter Executive Committee previously, and is currently the liaison chair with the USCIS Washington District Office. Okay, I know our panelists are very impressive. It takes a long time to go through their bios. So a quick overview of our presentation today. We just finished up the welcome and introductions. We're going to quickly go over bars to asylum, but then really the meat of our presentation today will be talking about terrorism-related inadmissibility grounds, or TRIG, as you'll hear us refer to it quite a bit. What is TRIG? What are the consequences of TRIG findings? Are there any exceptions or exemptions that we should know about? What kind of strategies should we be considering to get around TRIG findings? And then some fantastic hypotheticals that will help us really get a sense of what this looks like in practice. We will have hopefully some time at the end for Q&A. We do ask, please, that you use the Q&A box at the bottom of your screen. The chat function is not the best way to ask your question, because we do hope that everybody will be able to benefit from the great questions and answers. So please do use the Q&A box at the bottom of the screen. So really quickly, in case you haven't taken any of our Asylum 101 trainings, we just wanted to go really quickly through the elements of asylum in the United States before we talk about the bars to asylum, and then spend most of the presentation today talking about TRIG. In order to establish that somebody qualifies for asylum in the US, they have to show that they have a well-founded fear of persecution, either based on the fact that they suffered past persecution or because they would risk persecution in the future, on account of one of 5 protected grounds, either their race, religion, their nationality, their political opinion, or because they're a member of a particular social group. The persecutor if it's not the government who's persecuting them or who they fear will persecute them, if it's a non-governmental actor, they have to show that it's an actor that the government is unable or unwilling to control. So a couple of key things to keep in mind as far as bars to asylum go. It is a requirement that someone file for asylum within 1 year of their entry. That's often known as the 1-year filing deadline. We have that here as OYFD. If they were previously denied asylum by an immigration judge or the Board of Immigration Appeals, or if they could be removed to a safe third country pursuant to a bilateral or multilateral agreement. There are some exceptions to these specific bars to asylum. You'll find that in the regulations. We've included the citation to those regulations here, either that there's been some sort of changed circumstances in either the person's country of origin or in the person's life that would now lead them to fear persecution if they return home, or there were some sort of extraordinary circumstances that prevented them from filing within the 1 year, like illness or disability or holding some other status. We included that in red because that's something that we're hoping will apply for Afghans currently holding humanitarian parole. Really quickly, we're going to talk about a few bars to asylum before we get into talking about TRIG and the Persecutor Bar, which I highlighted here because I'm going to then pass it over to Professor Syed to talk a little bit more about those. So if someone has been convicted of a particularly serious crime, they are barred from a grant of asylum. We cite a couple of cases here that you're going to want to look at if you have a client who has a conviction, has a criminal conviction. If you want to, do the evaluation of finding whether it was a particularly serious crime, there's several factors to consider: the nature of the conviction, the circumstances underlying the conviction, what kind of sentence was imposed, whether this conviction would lead you to believe someone's a danger to the community. It doesn't necessarily need to be for an aggravated felony, which is a term of art in immigration law. For it to be considered a particularly serious crime, it can be a felony or even a misdemeanor. You really have to look at those specific factors. One thing we wanted to highlight here is that there was a case a couple of years ago, matter of GSS before the Board of Immigration Appeals, that said the person's mental health is not a factor that can be considered in determining whether their conviction is a particularly serious crime. That may be altered under newer precedent from the Attorney General this past year. So keep an eye out for that. The Immigrant Defense Project and the Harvard Immigration Refugee Clinic have a really useful resource that goes much more into depth on particularly serious crime. So we would encourage folks to take a look at that. Another ground for a bar for asylum is a serious non-political crime ground. This is something that it comes from the Refugee Convention itself. A couple of things to look out for if you have a client who has committed or arguably has committed a serious non-political crime. If they ever have had an Interpol red notice against them, that may lead an adjudicator to find that is really strong evidence that the person has committed a serious non-political crime. And then you also want to look at this Board of Immigration Appeals case matter of EA, which encourages adjudicators to balance the seriousness of the criminal acts against the political aspect of their conduct. For anyone who's had a criminal issue, certainly this next ground, the danger to the security of the United States, is something to keep in mind. Again, this is something that it's one of those you'll know it when you see it. Maybe you want to take a look at what the conviction was for, what's the nature of the conviction, and make some preparations to argue that they are not a danger to the security of the United States, notwithstanding whatever the conviction is for. I think lastly, before I pass it over to Professor Syed, we'll talk a little bit about firm resettlement. We want to take a look at whether your client has been living in another country prior to arriving in the United States, if they were offered or received some sort of permanent immigration status or permanent resettlement in that country. There's a pretty clear framework and analysis for this bar to asylum in the Board of Immigration Appeals case matter of AGG. So we would encourage, if you notice that your client has lived in another country prior to coming to the United States, we would encourage you to take a look at the framework in that case to determine whether they're barred for asylum on this basis. Not going to go into it too much because I am cognizant of time and I really want to make sure that we get to the terrorism-related bars to asylum. So everyone will have the slides for this, and if you have a client who arguably could have been firmly resettled, we do encourage you to take a look at this case law and also the exceptions to this finding. Okay, without further ado, Professor Syed, let's talk about the Persecutor Bar and the terrorism-related inadmissibility grounds.
Great. Thank you so much, Rachel. It's so wonderful to see so many people here. So Persecutor and I are going to fairly quickly break down the Persecutor Bar and TriG for you. It is complicated, but I think we've simplified it. So the first bar that we wanted to talk about is the Persecutor Bar. So as a policy, our nation has decided that even if someone qualifies for asylum, they've shown that they have suffered persecution and that it was on account of their political opinion or race, religion, nationality, we're not going to give them asylum if they have persecuted others on account of their religion, nationality, membership in a particular social group or political opinion. There's a couple of things I want you to keep in mind, though, for the Persecutor Bar. First, if the applicant has to have committed some harm that rises to the level of persecution, and you'll probably recall from earlier trainings, right, that persecution is an extreme concept. So not all harm will qualify as persecution. Second, that harm that was committed must have been connected to one of the 5 protected grounds. So just because an applicant has harmed another person or done something that led to harm to another person, that's not going to qualify as persecution if there was no nexus to a protected ground. I did want to briefly touch upon the viability of a duress defense. As you can see on the slide, it's up in the air. In 2018, in a case called Matter of Ngozi, which has a very, very long, complicated history, the BIA did say there was a limited duress defense available. Just 2 years later, the Attorney General under the Trump administration vacated that decision, and suddenly there was no more duress defense. However, last year, AG Garland referred that 2020 case to himself, and advocates expect that the AG may vacate the 2020 decision and bring back the 2018 decision where a limited duress defense was made available. So if this is a potential issue in your case, please do look into the Matter of Ngozi case. Now, where might the Persecutor Bar be an issue in your cases? If you are working with an applicant who has ever served in a military, an army, a police force, you're going to want to explore exactly what they were doing during that time, because that can trigger persecutor bar issues, particularly where the military or the army or the police force was known to violate human rights at that time or had a poor human rights record, or where the applicant, for example, guarded prisoners. Okay, next slide, please. Okay, so let's get into the terrorism-related inadmissibility grounds. So INA sections 212A3B and 212A3F provide circumstances giving rise to the terrorism-related inadmissibility, which I will refer to TRIG going forward. So next slide, please. Okay, so INA section 212A3B little I makes various things, makes people inadmissible for various circumstances. The one that I want to focus on most is the first provision, which says that any person who has engaged in terrorist activity is inadmissible. Now, there are 8 other grounds under this same provision that make applicants inadmissible for different things, such as inciting terrorist activity, being a member of a terrorist organization, receiving military type training from a terrorist organization, for being the spouse or child of someone who is inadmissible under TRIG, etc. But I want to focus on just this provision, the engaged in terrorist activity provision, because it is the one that is most commonly cited as an issue for asylum applicants. Something to keep in mind here, engaged in terrorist activity does refer to past activity only. The INA then goes on to actually further define terrorist activity and engaged in terrorist activity. So let's get into what that means. Next slide, please. So the INA defines terrorist activity, and that definition begins with this opening clause that says that terrorist activity is any activity which is unlawful under the laws of the place where it is committed, or which, if it had been committed in the United States, would be unlawful under the laws of the United States or any state, and involves one of 6 enumerated activities. So some things to keep in mind here to remember is that there is no conviction requirement. So your client or applicant does not have to have been convicted of terrorist activity for TRIG to apply to them, but the activity does have to have been unlawful either here in the US under either federal or state law, or unlawful where it occurred. So let's get into the 6 enumerated activities. So this slide, again, the first 3, not at all surprising, right? These are things that you would traditionally expect terrorist activity to mean. Hijacking, right? Kidnapping someone in order to force another government or group to do something. A violent attack upon an ambassador. Next slide, please. Where it gets more tricky and nuanced is the 5th provision. So subsection 5 says that terrorist activity encompasses using any firearm or other weapon or dangerous device other than for mere personal monetary gain with the intent to endanger the safety of one or more individuals or to cause substantial damage to property. So the reason this provision is so problematic is that it makes any activity with any sort of armed resistant group or guerrilla group qualify as terrorist activity. So, for example, if your client took up arms against the Taliban or against the Soviets, they may be inadmissible under this provision. There's a seminal BIA case called Matter of SK, where the BIA held that, freedom fighters, for example, people fighting a dictatorship in their country, fighting for democracy, groups that are supported by the United States, if they've used any sort of arms to achieve those ends, no matter how legitimate they may be, they have committed terrorist activity. So it's really, really broad. One example a lot of people use to sort of underscore how broad it is, in the American Revolution, right? Our founding fathers would have qualified as committing terrorist activity because they used some arms to achieve their ends of independence. Next slide, please. So as I said, engaged in terrorist activity is also further defined in the INA. These first four grounds are not as commonly cited or as problematic, but I did want you to just know about them. So committing or inciting to commit under circumstances indicating an intention to cause death or serious bodily injury, a terrorist activity, preparing or planning a terrorist activity, gathering information or targets for terrorist activity, or soliciting funds or other things of value for terrorist activity or for terrorist organizations qualifies as engaged in terrorist activity. Next slide, please. Soliciting an individual to engage in terrorist activity or to become a member of a terrorist organization also qualifies as engaged in terrorist activity. Next slide. And this is really the provision I want to focus on because it comes up quite a lot. So this provision states that if you have committed an act that you know or you reasonably should have known affords material support, the statute then provides some examples of what material support may be. That includes providing a safe house, transportation, funds, a material financial benefit, false documentation. And you've done this for the commission of a terrorist activity to any individual that you know or you should know plans to commit a terrorist activity, or to a designated or undesignated terrorist organization, you have engaged in terrorist activity. There's a few things to keep in mind here. One is that this, although it's very, very broad, it does require an affirmative act by the applicant. So for example, if a member of a designated or undesignated terrorist organization steals something from your applicant, that would not count as material support. However, if a member of a terrorist organization, holds a gun to your applicant's hand, demands that they give them some money, for example, the applicant complies, they have taken an act, and that would qualify as providing material support. Next slide, please. Okay, so there's some big case law that you do need to know that is important and unfortunately not really helpful. Matter of MHZ is the first one, and in that case, the BIA held that there is no intrinsic duress exemption to the material support bar. So in the example I just described, where a member of a terrorist organization holds a gun to an applicant's head and forces them to give them money, that counts as material support, even though they did that under duress because of what matter of MHZ holds. In addition, matter of ACM held that there is no de minimis exception to the bar. So, a lot of advocates had been arguing that, the provision says material support. So that word material must mean something. It was added into the statute by Congress for a reason. But unfortunately, in matter of ACM, the Board of Immigration Appeals held that the amount of support provided does not matter, that any sort of support counts as material support. So in that case, a Salvadoran woman had been kidnapped by the guerrillas, and she had been forced to provide them labor, cooking and cleaning. She was forced to undergo military type training for them, and the BIA found that she had provided material support. Another thing to keep in mind is that, there's also no exception for sort of routine commercial or social transactions. So like if an armed group, controls your town, they own all the grocery stores, and you go to that grocery store and you buy groceries because you need food to live, you have provided material support. If you invite a member of some armed group to your home, or even if they come unannounced and you serve them tea, as is required in your culture, you have provided material support. Next slide, please. So the last thing I wanted to discuss is the definition of a terrorist organization. You'll recall on the previous slides, a lot of the provisions talk about providing support, for example, to a designated or an undesignated terrorist organization. So let's get into that. The INA describes 3 tiers of terrorist organizations. So the first tier, tier 1 organizations, are known as foreign terrorist organizations. Foreign terrorist organizations are designated by the Department of State. You can find the list of designated foreign terrorist organizations on the Department of State's website very easily. Something to know about Afghanistan in particular, the Taliban has not actually been designated as a foreign terrorist organization by the Department of State. However, Congress mandated that the Taliban is to be considered a tier 1 terrorist organization by statute in the Consolidated Appropriations Act of 2008. There's also terrorist organizations called tier 2 terrorist organizations. They are on the terrorist exclusion list. They are also designated by Department of State. You can find the list of terrorist organizations or tier 2 terrorist organizations on the Department of State's website as well. Next slide, please. So I really want to talk a little bit now about tier 3 terrorist organizations. The reason I want to talk about this is because there's a lot of armed groups currently operating or that have operated in the past in Afghanistan, not just the Taliban. So it's important to be aware of tier 3 or undesignated terrorist organizations. So they're known as undesignated terrorist organizations because unlike tier 1 and tier 2 terrorist organizations, they are defined by their activity alone without undergoing a formal designation process. So immigration adjudicators, asylum officers, immigration judges determine whether a group is a tier 3 on a case-by-case basis while they are reviewing the asylum application. So these groups are defined as a group of 2 or more individuals, whether organized or not, which engages in or has a subgroup which engages in terrorist activity as expansively defined under the INA. Now, there's no need for this organization to endanger US national security. The organization could actually be supported by the US government and still qualify as a tier 3. Although we call them organizations, there's no formality needed for the organization. They don't need to have a name. They don't have to even consider themselves to be an organization. Another thing to keep in mind is that an asylum officer or immigration judge will conduct a tier 3 analysis, even if the organization no longer exists or no longer engages in violence. So to just give you an example of how broad this is, one commentator has written that under this tier 3 scheme, 2 teenagers who planned to smash up a storefront with a baseball bat for kicks would qualify as a tier 3 terrorist organization because of how expansively terrorist activity and undesignated terrorist organizations are defined under the INA. Okay, next slide, please. So if you're working with an Afghan applicant who wants to apply for asylum, there's certain things that you should be inquiring about. First, you're going to want to talk to them about any past membership in any formal or informal armed group. When I say informal armed group, I'm including within that things like, we might call a neighborhood watch, right? There's a lot of violence going on in Afghanistan at various points. And if the applicant, became or a member of a neighborhood watch, that could be an informal armed group. You're going to want to know, did they receive any military type training for this group? Did they ever use a weapon as part of this group? Did they ever take up arms against the Taliban? Did they ever fight the Soviet invasion in the 1980s? Next slide, please. In terms of material support, you're going to want to inquire about both any support given to the Taliban or any other formal or informal armed group. You're going to want to ask questions like, did they give money or anything else to get through a checkpoint? Did they pay a ransom or give anything else to secure the release of a relative who had been committed? Did they have any sort of commercial transactions with these groups? For example, did these groups own a store that they went into and made any purchase from? Did they ever host anyone at their home who was a member of these groups? Did they serve them tea or food at their home? Did they have any sort of social interactions with members of these groups? Did they ever engage in any voluntary or forced work for these groups, such as carrying weapons, cooking, or cleaning? Did they ever voluntarily or forcibly recruit anyone to join these groups? Did they ever voluntarily or forcibly solicit funds for these groups? Next slide, please. I also wanted to mention really quickly that the INA also bars people who didn't themselves commit any terrorist activity, but who are the spouse or child of someone who would be inadmissible under any of the terrorism bars. So it's very important to also ask if your client is married or if your client is a child about their parents' activities that may trigger one of the terrorism bars. Now, there are a couple of nuances you should know about this provision. So first, the activity of the spouse or parent that falls under TriG has to have occurred within the last 5 years. And there's also some exceptions written into the statute. For example, this wouldn't apply if the spouse or child didn't know or should not reasonably have known of the activity, or if there's reasonable grounds to believe that they have renounced the activity causing the spouse or parent to be inadmissible. Okay, I know that was a lot, and I'm going to now turn it over to Parisa to talk about some of the consequences of TriG.
Yes. I also want to ask, before we go through the consequences, Paris, from a practitioner's perspective, if there's anything, in your experience that we should be looking out for, anything that you've come across that would be useful for folks to know about here.
Yes, and most importantly, this is a very recent update that I think it's important for everyone to know about. This is from the National Services Center in Philadelphia that has resettled some 500 Afghan nationals. This is just brand new, just practice tips or practice feedback that has come in. Firstly, I think it's important to note that we should all understand that these Afghan nationals, although they've been paroled in and they are eligible for asylum protection, not to believe that this will be an easy case, not to believe that they will not analyze and assess these cases under the same framework and under the same guidance and under the same laws as has been in practice for many years. The one thing I have to say is that leading in the task force, we have tried to engage with USCIS to get guidance from them as to how they will handle TriG issues and the Afghan evacuees. And there has not yet been an issued guidance related to that. We just had a meeting with the Refugee Asylum and International Operations Director. They actually had a stakeholders meeting last week on the 25th, and this specific question was asked again. And the response was that we understand this is a very important issue, and we are listening, and hopefully we'll get some guidance, especially if it comes to the point of getting exemptions, especially hopefully getting some group exemptions, if possible, related to many of the activities that the Afghan nationals had to partake in order to be able to escape from Afghanistan. But before we get into what I wanted to just highlight and bring to everyone's attention is that And of course, while we're waiting for the Afghan Adjustment Act, I just wanted to put a tip in there also that that would hopefully happen, and that will save some of these issues, except that I'll go into the grounds of inadmissibility that will still continue to be partly reviewed for each applicant, even if related to an Afghan Adjustment Act. Firstly, as everyone should know, the Asylum Office, for the first time in 40 years or so, they are really taking the adjudication time window of the Congress really seriously with regard to the mandated 45-day expedite. And they are interviewing individuals within 45 days. And as mandated by Congress, they must have a decision within 150 days. So as practice pointer, don't file bare bones I-589 applications, because you have a very short window to turn these applications around. And as Rachel has already highlighted, the 1-year filing deadline, there is a specific 1-year filing deadline exception in that with regard to parolees, that they are can be argued, and again in meetings with USCIS officials, when we've asked them to provide specific guidance on that, they've turned around and argued that it is in the statute itself, and it's extraordinary circumstance, and therefore being in legal status or being in parole status is specifically named. So I say that so that you take care of not filing a bare bones I-589 application, or going a complete review of these TRIG issues with your clients before you file the application, because in some cases, it may turn out that you may need to hold off on the application if, for example, serious TRIG issues come up. So as already been explained, there are grounds of inadmissibility, there are grounds of deportability, and there are bars to refugee protection and asylum protection. Each one of those is completely separate and apart from each other as far as sections of the law that governs their particular analysis. Inadmissibility grounds are found in Section 212 of the INA, and they apply to applications for admissions to the US from abroad, or if you're filing for adjustment of status, filing for a green card in the US. Deportability grounds are in Section 237 of the INA, and that ground allows the removal of US of persons who previously may have been admitted. And then finally, there are bars to asylum and withholding found in Section 208B2A and 241B3B for withholding. And inadmissibility and deportability are not directly relevant for these bars to asylum, but you have to show you're not barred for asylum under TRIG. So each ground of inadmissibility will review TRIG under different sections. So that's how TRIG shows up being affected in different contexts. First, you have to prove for asylum you're not barred. For becoming a green card holder or applying for adjustment of status, you have to show you're not inadmissible. And then if you're in deportation proceedings, you have to show you're not deportable. So having said that, you need to make sure the consequences of TRIG are that you're denied any special immigrant visa. I believe that's the next slide. If we're
Well, before we go into the consequences of TRIG, Paris, can I ask you both a couple of questions that have come in through the chat that I think are relevant to this section? If you both don't mind, there were lots of questions about whether, clients who were former members of the Afghan military, which I think is a really good question. It's something that we've seen come up in some of the referrals that we've gotten at highest. They obviously received military training. They used weapons as a part of this group. Some of them may have taken up arms against the Taliban. These are, formal armed groups. I mean, what should we be considering here? What should we be worried about TRIG for these folks?
Well, firstly, I'll just give my little piece. The Taliban is technically, but although designated terrorist, de facto terrorist organization, it's still not on the list. The status, however, being a terrorist organization was also, Faiza brought the passage of the act that designated them technically. The status, though, is also affirmed through Carey versus Din, the Supreme Court case of Carey versus Din, 576 U.S. 86, 2015, which he was found, the gentleman who was in that case was found to be inadmissible due to his affiliation with the Taliban. So having said that, the other, I think, issue, my purpose here is to give you some practice pointer tips. And one of the things that has to be looked into is that whether or not the Taliban is de facto government. And terrorist organizations are normally designated not include a government entity. So that's one thing to try to argue, try to show that the Taliban for itself is the government. And so could there be material support or consequences of TriG related to a government? I'll have Faiza go through the exact provisions for military issues related to the question.
Yeah, what I was going to say really relates to what Paris too just said. Generally, a duly constituted government or entities of the government do not qualify as tier 3 terrorist organizations. So if they were a member of the Afghan military, right? The Afghan military is not going to be classified as a tier 3 terrorist organization. However, you may have other issues if they were part of the military that relate to the Persecutor Bar, right? If your client, do you actually want to go back? Yeah, thank you, Rachel. If you could go back to the Persecutor Bar slide, that would be great. Okay, so let's just look at this first provision, right? An applicant who has ordered, incited, assisted, or otherwise participated in the persecution of another person on account of their race, religion, nationality, membership in a particular social group or political opinion could be barred from receiving asylum. Now, a couple things to keep in mind. Mere membership in a group that was persecuting others at a certain point of time is not going to bar your applicant. So even if your client was part of the Afghan military or Afghan police or any sort of entity such as that at a time when they might have had a poor human rights record, that alone isn't going to bar your client, right? Your client has to have ordered, incited, assisted, or participated in persecution of a person on account of their race, religion, nationality, membership in a particular social group, okay? So there needs to be nexus, right? An army that is normally going out doing sort of normal operations isn't usually persecuting people on account of their race, their religion, their nationality, their membership in a particular social group. I say normally because there's definitely instances and in certain countries where the armed forces were, for example, persecuting people because of their political opinion. Negushi's case is instructive, where the army was going after people of a certain ethnic group. And Negushi himself was forced by the government in his country to guard these people who were being imprisoned solely because of their ethnicity or their political opinion. So generally speaking, is going to be very hard for me to give you a concrete answer because it's so fact specific. So you want to ask your client lots of questions. When were they in the army, right? And do some research about what the army was doing at that particular time. Are there any indications that the army was violating human rights at that time? That's not alone enough, right? Then you need to ask your client what they were doing specifically in the army. A lot of applicants are going to tell you, not much. I got trained. I didn't, I might not have ever seen any sort of combat, but it's very nuanced, right? You want to ask specifically when they were a member, what they were doing as a member, did they see any violence, and do your own also research into what was going on with the particular army or military that they were a part of during the time frame that they were a part of it.
Let me ask you a quick follow-up here. We have a attendee asking about folks who may have served with the Northern Alliance fighting alongside U.S. Special Forces in around 2001, 2002 era. That's maybe, I don't know if it would change your analysis if they weren't formally part of the Afghan military.
Yeah, it would. It would. If they're not formally part of the Afghan military or army, and they used arms, even if it was fighting alongside the U.S. Special Forces, they may then qualify as a tier 3, right? You're going to want to look at the tier 3 definition. And if they did anything that falls under the tier 3 definition, they're not going to get the same treatment as someone who was part of the actual Afghan military or army.
Really useful to know. And I think there was one question that came in before we move on about, I think it was more in the material support section. If somebody was engaging in kind of routine business transactions and sold something to someone who was sold something or purchased something from someone who was a member of a terrorist organization.
Yeah, so unfortunately that is going to qualify. It's a routine commercial transaction. They were like, I'm just living my life and doing routine things, but unfortunately, material support has been expansively defined, and routine commercial transactions where you're selling or buying things with the Taliban will qualify, but in a moment, we'll get into some exemptions that may be available for that situation.
Paris, do anything to add here?
No, just the only other thing I wanted to say is that routinely governments have not been designated to be tier 1 or tier 3, except that I need to just add that in 2019, the Iranian IRGC, Iranian Revolutionary Guard Corps, was added by the Trump administration. So for the first time, we do have a part of the government being added, and many Iranian nationals whom I serve are now stuck because of their compulsory military service are being found to be inadmissible. So having provided the argument to use that the Taliban could be de facto government, it may not work because we have the IRGC. But doesn't mean that you don't not use it. The other thing I wanted to ask was that matter of ACM, I'm sorry, there's so many cases. ACM is still lingering in the Second Circuit. So that may have some hopeful resolution. We're hoping for the best, but meanwhile, it is what it is. Going back to consequences of TRIG, as I've explained, it takes place in 3 different sections, but mainly you become ineligible for most sorts of applications, SIVs, it affects refugees, it affects asylum applications, I-730 petitions, withholding, adjustment of status, cancellation, and 212C waiver, family unity, but you're still eligible for CAT relief, naturalization, and I'm just going to touch on that in a minute, and visa petitions and other types of I-730s. And you could be subject to deportability and subject to mandatory detention. Now, although you're still eligible for naturalization, I'm going to share a matter for an Afghan national that I'm dealing with right now, where he came into the US originally and then became a permanent resident through employment status. And when he filed for his naturalization application here locally in the Virginia office, after many, many years, I think his case was pending pro se for over 5 years, and he finally received a notice of intent to deny. And for the first time, TRIG issues came up because he had in his village served as an educator for children, had written children's books, but that particular village and particular city was governed by rebel groups, and but governed, or actually the leader of a rebel group was the de facto government authority there. And so now he's facing TriG issues, but not in a naturalization context. So to say, they're now making a determination that he did not adjust his status properly when he adjusted, because USCIS didn't do his job back when he became a permanent resident. And we'll get into some of the retroactivity and issue preclusion and collateral estoppel later on, as there's a hypothetical, we'll get into it. But it could still come up many years later, even if your clients become permanent resident, it could still, USCIS could take a second look. And they do a lot of times take a second look at the N400 stage to see whether or not your clients adjusted properly, or there was fraud involved, or issues or waivers that could have been applied for that were not applied for. So the consequences are, the government will raise a TriG issue. In the context of asylum applications, one of the things that I will give as a practice pointer is that the asylum officers are quite versed in terrorism bar grounds, and they do a complete training for them. And you just need to make sure you vet your client properly. The most recent examples of asylum interviews that we're seeing around the country, and especially from the most latest one from the Philadelphia Nationalities Service Center, they are all reporting, and I myself have had 5-6 hour interviews. Sometimes 2 officers are here in the asylum office, and they're actually really grilling the clients for how they got out of Afghanistan. That question, checkpoint questions are asked always. How they obtained their passports or other documents, their work, their how they obtain jobs. And most importantly, you shouldn't take these questions lightly. You should really vet your clients. Most recent example was at the interview in Philadelphia. The applicant was asked in an interview where the applicant started mentioning that he had given bread to a talib at the door of his house during the first Taliban government in the late 90s. And the client apparently was a child at the time this had happened. And the talib, and I'm just saying that word because I'm going to give an explanation, T-A-L-I-B, was a student from a local school, madrasa, who was begging for food. And so a lot of questioning went into that particular transaction. And so I think practitioners need to also understand the culture and maybe the language, because talib literally means student, somebody who seeks knowledge. And so it means student. And in many times in schools in Afghanistan, orphans and other poor children are sent to these schools that are attached to local mosques. And then in the mosques, if they're not getting the nourishment, or the children have gone door to door begging for food. So I think as practitioners, we need to be aware of a lot of these cultural histories and cultural facts. So the talib could mean a student or a fighter. So just because your client is describing giving something of value, or bread in this case, to what he's terming to be talib, doesn't necessarily mean or meet the threshold of the Taliban. So these are really literal questions that you as a practitioner have the opportunity to bring out during the interview. When you go to an asylum interview, the officer sets the ground rules. And I don't know if maybe you've all been there, but I'm just going to give a quick, a practice pointer. At the end of the third section, where the attorney is allowed to speak, I think that before you give your closing arguments, before you summarize how your clients are eligible for asylum protection, you make sure that any questions that are left to the imagination or misinterpretation of the USCIS officers is covered at that time. You turn around and you ask your questions from your client to describe the individual to whom they provided this bread, for example. What do you mean by talib? What does talib mean? Get the interpreter involved. Ask these specific questions to bring out the facts, because you have to bring out the facts in order to argue the law. So at the end of the interview, make sure you cover all grounds, make sure you ask these necessary questions. You may get some hesitation from the asylum officer, but just ask, professionally and respectfully ask the officer to give you that right to bring out some of the facts. And a lot of them I've seen, nod their heads and allow you to do that. Also, make sure you get into the facts related to, because right now a lot of the questions are being asked about checkpoints. Now, during that Afghan evacuation in August timeframe, there were a lot of other armed groups or other individuals, Pakistani rebel groups or others, who were actually abusing the system and abusing what was happening and taking money from people to be taken across from checkpoint to checkpoint. So don't just assume that your client paid the Taliban. Have them explain, have them describe who it was who received any goods, jewelry, funds, in order to pass from one checkpoint to the checkpoint or get their passports or identification. Now, the grounds is clear and convincing evidence. That's your burden. But I think if you are able to at least bring out the facts and show that this material support, there's questions about the material support ground, you've covered yourself as best as you can. Going forward, I think if we go forward to the next slide for the exceptions related, okay, we're there. One of the things is that, and I just covered that, just make sure you understand the lack of knowledge. And it only applies to tier 3, so we're limited kind of to the Taliban, but there may be other groups to whom your clients have given food or some kind of goods or something of materiality, and you can basically argue lack of knowledge, and you have to show, as it provides here, that there's a subjective and an objective lack of knowledge, that the applicant didn't know and could not have, a reasonable person in his shoes would not have known. And again, as I explained, it is clear and convincing evidence. It's a high burden. And it doesn't apply to receiving military type training or being representative of an undesignated organization, as the question had asked, and Faiza provided a response for that. When you go to the next slide, the material support knowledge, again, applies to knowledge of the applicant's act itself, provided the material support to any organization at all, or for the commission of a terrorist act, or to an individual who committed or plans to commit a terrorist act. And again, this only applies, unfortunately, to a tier 3 organization.
I actually think that last bullet is an error.
Okay.
The material support knowledge exception applies to all tiers. The bullet above is correct, right?
Yes. Yeah.
Yeah. Sorry about that. We will fix that.
That's fine. And I wasn't actually focusing on that particular last point. Thank you for catching that. All right. So now, when we get into exemption, the statutory authority for the exemptions is found in INA section 212 D3B. The implementation of the statutory authority is an interagency process and followed by a case-by-case application. So the way it works is that the DHS has a broad statutory authority. It's a very slow process for getting these exemptions at the DHS level. They have to confer. I'm just giving a background about how these happen. There's no specific application for an exemption. So I just wanted to make that understood, that unlike other inadmissibility grounds where you're filing an I-601 waiver or some type of a waiver application in order to get an exemption, a discretionary TriG exemption, there is no specific filing of any forms or any filings with DHS. DHS has the authority, and they involve themselves with other agencies to see if any of the exemptions are to be implemented. And there are basically two types of exemptions. Well, I think I've covered the next two slides already. Also in removal proceedings, if we go to that next slide, or the slide with removal proceedings, the immigration judge does not have authority to grant an exemption. It's only the DHS memo addresses that only applicable to DHS. So in order, if you find your client is in removal proceedings and an exemption is required in order to be granted asylum status, the way the process is that the individual will have to have a final order issued, and then the file is routed, or the application is routed to DHS for review of a discretionary exemption. And the memo is cited in the 2008 memo is cited in the link in the PowerPoint, which I know will be shared with everyone. So in general, there are two specific exemptions. There is the group exemption and the situational exemption. And so, again, we have to take into consideration that the general requirements of exemption eligibility is you have to make sure you before you get to exemption, make sure your clients understand the challenges of these exemption requirements are met, and most of them are discretionary. All of them are discretionary, and make sure they understand that it could be negative interpretation of the discretion. And so all of that, these warnings should be given to the applicant before they go forward with their application that may or may not require an exemption. I would FOIA the file after, let's say your client comes in as a refugee or asylee and wants to file adjustment of status, and it's in that context that you are engaged to serve. I would definitely FOIA the file to see if at the time of getting an asylum application granted, how or if those grants have been already provided in the FOIA with regard to if the officer has made any notes related to exemption eligibility for the client. So if we go to Afghan nationals, unfortunately, we don't have a group-based exemption. And so what we only have is that the only one that is applicable for Afghans is for everyone else. We have the exemptions under situational exemptions. I think the next slide. I'm following my own. Yes. So the situational exemptions have several sections: material support under duress, solicitation under duress, military type training under duress, voluntary medical care, certain limited material support, insignificant material support. And the general requirements is that you have to show in order to meet these particular exemption is that you're seeking a benefit or protection under the Immigration Nationality Act, and you've been otherwise determined to be eligible for the benefit or the protection. You've undergone and passed all of the background and security checks. you have, and this is a key section, you disclose in all of your application and interviews with the US government representatives, all of your past affiliations and material support interactions and any other activity within the scope of the Act 212 under 212A3B, as well as all contact with a terrorist organization and its members. And then finally, you have to show that you possess no danger to the safety and security of the United States. And that's why FOIAing the file, especially if the person has come from overseas, may make sense, not FOIA just with USCIS, perhaps FOIA State Department files, CBP files. And I think that's one question. Faiza, I'm going to pose that to you. Let's say your client came in on humanitarian parole and got port parole from CBP. And at the time of port parole with CBP, he didn't disclose any of his affiliations or any of his interactions with back home, with any of his interactions at all in his life. Would you think that he is still eligible for an exemption?
Yeah, I would argue that they were not asked, because a lot of the times for a lot of applicants, they don't even realize that there is a TRIG issue, right? Like in your example, if that person had given, let's say it was a Taliban member, some bread, often they don't know. And often it only comes out when the asylum officer asks. And the requirement would be that when asked, they would have to be fully forthcoming, right? That's what I would argue. And in my experience, what the situation you're saying, where they were, questioned by, the CBP officer, but the CBP officer didn't ask about that. I haven't seen that to be an issue in the past. Not that they can't suddenly change their policy on that.
Right, but these are good, I think, thinking points for you to address, because all of our clients who come in through the parole through CBP, who've received that, DT or WT or OAR when it came in. So, I mean, you have to make sure you think like the officer when you're prepping your client. So. These are the issues, and I agree with you in that the questions were not asked. Another thing I would just give it as a practice tip, when your clients are providing, or you're providing the declaration that goes with the I-589, just have the clients, you don't need to have the whole biography of the client from birth to when they entered the US as part of the asylum application. Just address the questions, address these questions, specific questions on the I-589 and their fear of returning back home. Leave aside any of those, I lived in this village and the Taliban would come and visit us every 2 minutes and ask for food. And, you will get that addressed at the interview, and prepare your clients for these questions. But again, you don't need to get into so much detail about things that could work against your client. So that's just
this is a follow-up question for you, Paris, too, and I guess for Faiza also. If you know that something is going to come up as a TRIG issue in your client's case, do you want, what would you say is best practice? I mean, should you kind of bring it up, be forthcoming and really open about it? Should you plan to brief or provide the asylum officer with whatever exception or exemption might apply to their case, ahead of time? How should we be approaching that?
It's a great question. I think Parisa too was basically getting at that. The asylum officers, they have the questions, and they're going to ask almost all Afghan applicants the same sort of questions to get at material support, to get at other TRIG issues. So again, it's a judgment call that you're going to want to decide yourself if this is what you're comfortable with. But I do tend to agree with Parisa too, that I'm not going to, in my affidavit, raise all these issues, or in my brief raise all these issues, because when you get to the asylum office is going to ask all those questions. They're also supposed to be asking all of the questions that would indicate whether or not an exemption is available. So I completely agree with Persecutor that you're going to want to prepare your client. You yourself need to know if there's a TRIG issue. You need to prepare your client. They need to know what a TRIG issue is. They need to know how to answer the TRIG questions the asylum officer is going to ask. They need to know about the facts they need to talk about for an exemption. In the actual interview, right, you're going to want to pay very careful attention and make sure, as Persecutor said earlier, that all of the relevant facts are coming out, and be prepared at the end to ask some more questioning yourself. If, for example, maybe your client had a knowledge exception and the information for that didn't come out, or there's a certain exemption that you believe is applicable and the AO for some reason didn't explore that exemption. That's how I would handle it.
Yeah, same with me. But the only other thing I wanted to say is that in the context of the interview process, normally when there is going to be a TRIG finding, most likely you're going to get a Q&A, a sworn statement, and your client is going to have to sign off. And make sure you read that Q&A and add to it. A lot of times the officers are taking notes and they're just trying to capture everything, and then they print it out and they have you and your client review it. Make sure you detail and add to that, because you're allowed. That's a statement, and that should trigger to you that they're finding TRIG, and they may be sending this over for an exemption review. And so make sure you also get a copy of that that statement, Q&A statement, before you walk out. You're entitled to it, and you shouldn't be shy. And most officers they understand, and they give you a copy in any way. So with regard to the practice tip, I would also, the other thing I wanted to say is that a lot of times when these issues come up and I argue at the end, I ask, and the officer is asking additional questions. I've asked the officer if I'm allowed, or if she will give me additional time to brief particular issues that may have come out during the interview. And they're so far, and then they all laugh and they say, oh, this case is going to take a while anyway for review. And so they usually give me time to brief it, and then they usually provide, here locally anyway, at the ZAR, Arlington Asylum Office, they've always given me their email address to which I can send a copy of my brief, any additional factors that I wanted to brief with regard to what has come out during the interview. Because as practitioners, I've been practicing for 3 decades, what you expect and what comes out at the interview are always so different. And every case that has happened to me, every case things come up. And as I just pointed out, that whole scenario with the applicant talking about giving bread to a talib, the attorney was not prepared for that, or didn't know this was going to come up, because the officer was digging, and then, the client went into, back of his mind and brought out that story. So where were we? We're into the exemption.
We're talking about material support under duress. Yeah, I want to bring us back here because I know we have quite a bit still to cover. We're running a little short on time.
Yeah, and I think Liza has already covered duress, because basically it doesn't exist. But we are, with regard to we're at exemptions right now. Yeah, exemptions, material support under duress. It requires, I think everyone can just read the pointer and just look at the practice pointers are the most important one. Look to see if the applicant could have avoided or took steps to avoid to providing material support. Now, one practice pointer I will give, and it's not laughable, I laugh, I should cry about it, is that if your client, and I guess an argument to be made is that, let's say the client obtained or paid a sum in order to get through a checkpoint, if you can bring out the facts to see if that was done under duress. So ask the client to explain the circumstances in which the payment was made. Did you approach the individual and give him the money? Hey, let me go get passed through. Or were you driving on your way, and they came with guns pointed at you and forced you to give the sum of money or whatever in order to get to the checkpoint, in order to get a passport. One other thing that I'll just bring up in that, although you're supposed to have a passport, and this really applies to individuals outside the U.S., but if I've already explained that if you didn't know who the group of men who were demanding the money from you were, make sure you bring that point out. And however, individuals in Afghanistan and mostly Department of State officials always believe that if someone's demanding a bribe or travel fee or working in the government, they are associated with the Taliban. And so I've already explained, if you have anything substantial evidence that the person is posing anything other than Taliban, is some kind of a rebel group or a Pakistani official taking entry fees, bring that out, vet that out. And then the other point I just wanted to make is that, let's say the person doesn't have a passport or lost their passport or birth documents, and they didn't want to pay the terrorists for a new one. And, basically just, you can have an exemption for a passport or a document, and you just have to make sure your client comes out and explains that I don't have a passport because I didn't want to pay the terrorists to get one. And that's like the best client to have, because if your client didn't actually go through that length of paying. Unfortunately, I have read of decisions where very horrific decisions. That's the part I said I shouldn't laugh, but in any event, where the individual didn't want to pay someone who was a Taliban or an armed rebel who was going to rape or kill members of his family. He called him out at the bluff. He wouldn't take that. And so they killed the family members. And you would think the case would be granted right then, but after the individual buried and I'm giving you examples because I think the PowerPoints are there. You guys can take your time to read it and look at it. I'm just giving you some practice, examples and things that to think about, horrific things in this point, where the individual was, in fact, went ahead, and this is another colleague's case altogether. The individual's asylum was denied, but CAT was granted because the person buried the family members, and that was itself seen as a bar. Don't ask me why. That's a sad case, but in any event, that's how broadly these cases and these issues are looked at for material support. Because again, as the case which is now in the Second Circuit, that was a horrific case, and that was like the most egregious kind of case where you're forced to cook and clean for or someone who's threatening to kill you, but you're still denied asylum protection for that purpose. And unless we get away from that bad case law, we're going to have these horrible decisions like that. I wanted to also bring out in the context, if we move forward, I think to, I guess, key takeaways, because I just looked at the time and I want to leave some time for, yeah, there we are. Again, I've already explained, it was, make sure you go through the process of seeking out the facts of the case. And, one of the things that I think everyone should know about a practice of immigration law is the word totality of circumstance. It applies in everything, in every situation. Always at the end, make sure you argue totality of circumstances, because that is the one key phrase in arguing the equities or the non-application of TriG, perhaps, if the that works in your case, for the findings that will be made against your client. I wanted to just touch point on these exemptions. Are there any questions that are there related to any of these exemptions that we can perhaps address the exemptions through questions?
Yeah,
There
I think sorry, go ahead, Faiza.
I did want to answer this one question. I think the latest one that just came about. An anonymous attendee asked, where can we find DHS's sources, guidance, or other resources on the material support exemptions, especially duress, since the BIA says there is no such exemption. So I just want to clarify, because I agree that it is very, very confusing. What the BIA said in ACM and MHZ is that there is no intrinsic exception within the statute itself. So they read the INA, they went through the legislative history, and they decided, having looked at all of that, there's no exception in the INA itself. However, another provision of the INA, 212D, I can't remember it, but it's on the slide, says that the Secretaries of State and Homeland Security have the authority to create exemptions, right? So exemptions are things that are not necessarily already within the INA, but that can be created. So practically, what does that mean? That means that the INA itself, the BIA has found, does not have a material support under duress exception. However, under INA 212D, the Secretaries of State and Homeland Security can create an exemption for that, and they have created an exemption for that. And we actually have the links on the slide. So if you want to know what exemptions exist and all of the particular things that you would have to show to get an exemption, you can just go to the links that we have provided. So I just wanted to clarify, because I know that can be very confusing.
Yeah, and in the past, there has been exemption authority exercise, especially if you go back to the Syrians. There was some exemptions that during the Obama administration enacted in, I think, 2014, where it provided a group exemption with regard to Syrians who are coming. So that's the type of exemption we're hoping for Afghan nationals as well. But we don't have the guidance yet. The other thing I wanted to just really just quickly talk about is that each of these exemptions has a different type of significant restrictions. For example, they're related to the certain limited material support bar or insignificant material support exemption for related to the certain limited material support bar or exemption, I'm sorry. The requirement is that they could not have intended to assist the group. For example, let's say you own a bakery and the armed groups, and again, these are only applicable to tier 3 organizations. So they're not applicable basically to the Taliban. So let's say these rebel groups, armed groups would come to your bakery or your restaurant and they would eat. And so they were paying you, you're not paying them, right? And so you're arguing for a certain limited material support because that would be certain routine social transactions. That's the section it would fall under, or certain routine commercial transactions. You have to show that the applicant didn't have the intent to assist the group. So the payment that they were paying was for the food. They were not, you as the store owner or the bakery owner was not allowing them to use that money to benefit or assist the group in any other way. For the same thing with the insignificant material support exemption, the support should not be to further the violent activity. So the exemptions that are in place, they have different restrictions, and you have to argue them a little bit differently if you're going to brief the asylum office or brief the other officers. So just make sure you you go through all of the exemptions and the requirements for each thoroughly with your clients, and then when you get to the asylum office, we can further argue that in your favor. So we've got a couple of hypotheticals that I just wanted to go into just really fast. So we have the hypothetical Ahmed, who and he and his family were constantly visiting by the Taliban at their home. And, you know, they were demanding food and shelter in summer of 2007 and demanding, you know, and they were forced to provide. So we have this particular date because the designation of the Taliban as tier 1 group by statute was through the Consolidated Appropriations Act of 2008 that became effective as of December 26, 2007. So that's a little distinction in relation to the time frame where this material support food was given. So by December 26, 2007, the Taliban was a tier 1, but before that, it would be a tier 3. So this particular hypothetical, Ahmad would be subject to a tier 3 material support because fall of 2006 to summer of 2007 fell during the time frame when the Taliban was would be considered a tier 3, not a tier 1. So the exemptions that we've provided would be applicable to this particular time frame because you look at the time frame in which the activity happened as far as the designation of the organization, the terrorist organization. And then moving forward, August of 2021, Ahmed and his sister were able to get evacuated from Kabul, but had to give money and goods in order to get through several checkpoints. Faiza, I'll bring that out to you. I think you agree with me that would be material support. But then you would try to fit your applicant into some of an exemption, hopefully to duress, if you can bring out the facts that they were armed and they were, pointing guns and they were demanding. I don't know what other tips you would give as far as arguing an exemption.
Yeah, I mean, if they're going through checkpoints and they're giving money and goods to get through the checkpoints, obviously the first thing you want to ask your client is, who are they giving the money and goods to? Right? Did they know? Were they actually Taliban members, or did they just assume that they're Taliban members? You want to get the nuance there because they might not be actually members of the Taliban. They could be any number of actors who are demanding money and goods. Then you're going to want to look at, were there duress factors, right? Were these people armed? What did they know? What did they think might happen to them if they didn't give the money to get through the checkpoint? Was that the only checkpoint? Was that their only route out, right? If that was their only route out, that makes it more reasonable that they gave the money, rather than if they had, multiple routes out and others didn't have checkpoints. But yeah, you want to talk about who it is that they're giving money to, how they knew who those people were, whether these people were armed, whether they had alternative routes, what they thought might happen to them if they did not give the money or the goods.
If we go to the next hypothetical with Rahman, and we have this one in because in the context of you're going to get, as I've explained before, we highlighted already, you're going to get TriG applicable in more than just the asylum context, in the adjustment of status application also. And this happens quite a bit. And there's a whole group of elderly Afghan nationals who have come to the US as refugees or have been granted asylum status, but for years, either their I-485 adjustment status applications are on hold or have been denied for their involvement with the Afghan Mujahideens in order they were engaged in armed struggle against the Soviet Union in the 80s or during that time frame. And so you really need to screen your applicants, especially males, who are over for that age group, 50 and above, I suppose, to see if they were involved during that period of time with any arms conflict. And I've seen this repeatedly for individuals who have been given protection and USCIS denies their asylum application. Now, there's a whole bunch of case law. Most significantly, there is the Fifth Circuit case of Amarella versus Napolitano in 2013, which I've actually used myself in federal court to based on the same argument. If your client was given asylum, especially in court in an immigration setting, there is an argument to be made of issue preclusion or collateral estoppel in arguing that this issue was already dealt with, this issue of TriG was already dealt with, was already vetted, it was already determined by an immigration judge before the applicant's asylum was approved and granted. In my context, I had a client whose I-485 was pending for 14 years, and he had obtained his asylum status in court based on the fact that he was a member of the Mujahideen when he was 16 years old. All he did was distribute flyers and pamphlets. And we argued Amarillo and here in U.S. District Court in Eastern District of Virginia. And we argued a collateral estoppel, and finally the client adjusted his status. So those are issues, these issues will continue to come up in the context of adjustment applications. So you make sure that you know the facts of your case.
Thanks so much, Parastu. I know we're running very, very short on time. We're running over. I want to make sure that folks have the CLE code if you're seeking CLE credit. That CLE code is 459ASY, like asylum. Again, it's 459ASY. You know, we are at time. We've been working to get through the Q&A box during the presentation, but if any other questions have come up, please do feel free to shoot us an email if your question did not get answered. Thank you so much to Professor Faiza Sayed. Thank you, Parastu Zahedi, for joining us today. This was a really fantastic seminar. There's so much to know. It's such a difficult area. I think everybody feels a little, overwhelmed and a little bit of doom and gloom. Do you have any words of optimism or anything to any closing thoughts on what we can hopefully look forward to for these cases?
It's not all doom and gloom is what I would say. I think the best thing that you can do is what Rachel just said, which is know your case well, know the facts well, prepare your client for the types of questions that you expect, right? The AO is going to ask a lot of questions about material support. Make sure your client knows that. And I think if you do that, if you know your case well, you prepare your client well, that's the best we can all do, right? And so you should feel good that you were able to, guide your applicant, guide your client through this process, a process that if they had to go through themselves, they would almost for sure not be able to get through successfully. I hope that's encouraging.
I would echo what Faiza said. The only thing is also I would just add, if you're not familiar with Afghan nationals, especially if you've never had an Afghan national interaction with them, or actually, I would say, I'm not just going to say Afghan nationals, everyone on that area of the world is almost the same culture. Acclimate yourself and become somewhat familiar. I think part of my practice as an immigration lawyer, I think one of the things I enjoy the most is becoming aware and becoming, having knowledge and getting knowledge from other parts of the world and cultures that I would otherwise not be ever familiarized with myself. So get to know their background of the country, the history of the country, and the culture of the country. One of the things I would highly encourage everyone to do, especially if you have a female applicant, they're very shy. You really need to work with them to get things out of them. You may need to meet with them separately, apart from male husbands, fathers, or grown adult sons, or any male in their family. It is a male oriented, dominated culture. So in order to get some of the facts out, especially from female applicants, you need to make sure you get all the facts and everything out one-on-one from each of your clients. Just work your best. And I think I do have hope. I think everything should go well. And I think if we have any questions left, I'm happy to answer questions if they're emailed to me. That's fine.
Thanks so much to both of you. Paris too brings up a really good point. A good chance for me to plug the previous webinar in our series on cultural humility. So if you didn't get a chance to view that webinar, the recording was just dropped into the chat. So take the time to review it, especially if you're unfamiliar with a lot of the nuances or the cultural background of this population. With that, I think we are going to call it a day. Thanks so much to our fantastic presenters today. Thanks everybody for joining us.
Thank you.
And we look forward to having you at our next session. It'll be the 15th of March on preparing your client for their assignment.